His Excellency Gachagua, lead counsel Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachagua's counsel to exit the proceedings. They maintained that the Senate, across the judicial body, exercised discretion in granting adjournments, and His Excellency Gachagua's counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachagua had actively participated through his advocate's opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachagua, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint. Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for the 24th of April 2026, and they were highlighted by their legal team led by Professor Tom of Gender Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola, and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachagua was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi alteram partem rule to define the threshold of a fair trial. They relied on the Black's Law Dictionary, 7th edition, at page number 725, and the Halsbury's Laws of England, 5th edition, 2010, volume 61, at paragraph 639. The dictionary defines the right to be heard as follows, and they quote: the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. End of court. To bolster their case, the Senate and the Speaker referred to the President in Evans and it must be reasonable. Council drew further support from the Uganda Supreme, the opposing evidence, and given a full venue to present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachagua fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary of video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute prerequisite for natural justice, and they fortified their position through the decision in Economic Freedom Fighters and 3 others was a Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwarjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to the case of Jacob Ochanda versus Kenya Hospital Association Limited to demonstrate that a hearing can be fairly conducted through written representations. The Speaker and the Senate faulted His Excellency Gachagua, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that the Senate acted within its lawful discretion when it denied His Excellency Gachagua's request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate and the Speaker emphasized that courts must be slow to interfere with internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous cycle agencies case and 4 others versus Maskulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision. And it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to re-evaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachagua's claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3B, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that Such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate, rendering or referencing the matter of interim independent electoral commission, and the Court of Appeal decision of Cooperative Bank of Kenya Limited and versus Banking Insurance Finance Union, which is a Court of Appeal decision. They contrasted Article 135, Subarticle 3B with Article 152, Subarticle 7 of the Constitution, which uses the mandatory phrase, shall appoint, when dealing with the dismissal of Cabinet Secretary. It was their case that since a motion to form a special committee was moved but failed to be seconded under Standing Order 70, the Senate properly proceeded in plenary, meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Sonko case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate to conduct a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate would be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145(3)(a), the Senate acts exclusively as a quasi-judicial body evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Articles 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-thirds gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law, and the 13th Parliament was lawfully established following the general elections of the 9th August 2022. Seeking to rely on Article 261, Subarticle 5 running to 7, the Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional crisis, invalidating national budgets, legislation, and public appointments, which violates the governance promotion mandate of Article 259 of the Constitution. They urged the court to practice judicial restraint as the gender dispute is actively pending before a 5-judge bench in Conchela and others as the Chief Justice and President of the Supreme Court in Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct an approval hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Subarticle 1 of the Constitution, expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of Federation of Women Lawyers Kenya, FIDA versus AG, the Initiative of Strategic Litigation in Africa, statutes could be interpreted to override the explicit statutes could not be interpreted to override the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the 5th respondent's case. The Attorney General, that is the fifth respondent, challenged the petition through grounds of opposition dated the 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments, since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the removal proceedings against H.E. Gachagua were purely legislative, neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, expeditious, and procedurally fair, since the adopted procedure successfully balanced the need to protect H.E. Gachagua's constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision, and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the